Welcome to the latest episode of the Common Law podcast. Today we are discussing another landmark case of Street and Mountford. Now, the fact that I know that that's the case we are discussing is basically because my colleague Neil Funch, who sat here with me, director, partner of our commercial property department, specialises in agricultural law. The reason I know this is I don't think he got the memo that said you're not meant to tell me about the case until I'm hearing about it for the first time as we sit down. But you told me yesterday what it was about.
I thought you'd already know instantly about the case.
No, I do know about the case. It's one of the ones I kind of do know about, actually. I didn't know about Tulk and Moxey the other week, actually. I definitely hadn't heard of that one. And I hadn't heard of the High Trees case. No, I hadn't really. I think I sort of knew, obviously I knew that Lord Denning and propriety estoppel and it started somewhere, but I didn't know about those ones. But I do know about Street and Mountford because it is all about, I guess, interpretation generally, but more specifically, what is a lease?
Yeah, so what is a lease? Well, most people will know that there are probably two types of property ownership. You can have a freehold,
yep,
and you can have a leasehold. I think people wouldn't potentially say if you own the freehold, then you own
it full stop. Yeah,
perpetual rights to it. You can buy, sell it, etc.
Yours forever.
Yours forever, subject to some exceptions. Leasehold, I think, is more tricky. I think people understand the principle that leasehold is something separate to freehold. But what exactly is it? I mean, it's been around since feudal times. You have a
1066.
You have a landlord and you have a tenant. The landlord is the one with all the power, and the tenant, if you're the tenant, then you have an inferior interest. But a lot of people say to me, well, if I have a lease, does that mean that I own the buildings and not the land?
It doesn't mean that, does it?
It doesn't mean that at all. You own the land and any buildings on it for whatever period you've agreed in the lease. And typically you will be paying either some sort of rent, maybe a small ground rent, to the freeholder or somebody with a superior interest for that right. And therefore that leasehold interest is also a very valuable property right.
It's an asset in and of itself.
You can buy, sell it, you can mortgage it. Most flats are leasehold. And there's still a lot of leasehold houses in this country.
So how did the case of Street and Mountford come along?
So, I mean, this is a case now that's just over 40 years old.
Oh, this is a bit like, do you now feel old? This is what the kid from Malcolm in the Middle looks like, or whatever.
And really what it was about was what is a lease? And
right.
Why was that important? Well, it's about because a lease is a valuable property right. And most legislation that gives tenants rights all centre around having a lease.
So by the time we get to the mid-80s, when the legislation is, there has been some legislation in the 70s, and actually sort of build-up of legislation, most of which is trying to give tenants more security, the person who holds the leasehold interest, more protection.
So it's to give the tenant rights against a landlord, simply kicking them out.
But the landlords were onto this, weren't they?
So if you were a landlord, you didn't want your tenant to have a lease.
Yeah.
Because if they did, then they would have all sorts of statutory rights that couldn't be contracted out of.
So what did those pesky landlords come up with here?
So the landlords were trying to find a device whereby they could allow a person to occupy a property but not actually have a lease.
Okay.
And they were doing this by having a document that simply was called a licence,
right,
which was not a proprietary right, that didn't confer any statutory rights, and would allow the landlord to be able, in many respects, to terminate.
And take what he saw as his property back.
Yeah. Which wasn't really in the spirit of what the legislations to give tenant security of tenure was about.
So we get to Mr. Street and Mr. Mount. Is it Mr. Street and Mr. Mountford?
So it's Mr. Street and Miss Mountford.
And Miss Mountford, okay.
So Street decided that he was going to grant Mountford a licence. Okay. For all intents and purposes, he granted exclusive possession, I think, of a couple of rooms.
In a pub or something, wasn't it?
Yeah, or in a house.
In a house.
Or some sort of residential dwelling. Was charging a rent.
Yeah.
And he purported to say that this wasn't, in fact, a lease.
It was a licence.
It was a licence. And so it didn't confer any protections.
And this was despite the fact that presumably she had her own key to the door of those two rooms. Mm. She was the only person in them.
Yeah.
She paid a rent.
Paid a rent.
Did you see what I'm doing here? By the way, I'm ahead of where you're going. I think this is what they call foreshadowing. But to use some terminology that lawyers always love to do, in lease terms, this walked like a duck, quacked like a duck, had wings like a duck. But Mr. Mountford was trying to say it's not a duck, it's, I don't know, mallard? Is that type of duck? Insert other bird here. That analogy's fallen down just right there. He was trying to say it's a licence and had written it up as such so that she didn't have the rights of a tenant.
Yeah. So ultimately we end up at the then House of Lords, who didn't think very much of that.
The House of Lords, a.k.a. now the Supreme Court. Yeah.
So the highest court.
Final boss of courts, basically.
And what we get out of that case are the sort of maxims that I think I probably learnt on the first day at law school, and what we're all familiar with about what actually
hit the viewers with these. So
what we learn from that case is what actually are the key tenets of a lease. So exclusive possession. Exclusive
possession meaning. So if we do lease, let's explain them.
Meaning that the tenant can exclude the whole world, the landlord, from the demised premises.
She's got a door. She's key. Pocket.
Yeah, nobody else is allowed in there apart from her or her family or guests.
That's number one.
For a rent, so payment of sum of money, and for a term.
Yeah.
So a particular period of time. All those put together indicate a lease, whether or not you're calling it a license, whether you're calling it something else. So, we just to use an equitable map, we look at the substance of what it is that's actually going on rather than what the form of the document is.
And we see this quite a lot in law, and the it's sort of the trying to stop people almost being too legalistic, trying to create documents which are fictional. We sometimes see this in employment law with contractor contracts where an employee is called an independent subcontractor, yet they get a company uniform, holiday pay, specific hours, and the law will say, no, you're not self-employed. You are an employee. But it's that in the land law context, really. Well,
it is. And of course, the reason why this was so important was because of the statutory controls that were placed on residential tenancies. Certainly at the time, they were very, very, very tenant friendly. I think this particular one ended up being a Rent Act tenancy. Now, I mean, later on, all those protections have been.
I was going to come on to that in a second, but you're right. Where we were in 1986, is it the 77 Act or the 78 Act had in effect could mean, certainly in residential context, you virtually almost impossible to.
Absolutely, you could end up with a tenant there who had succession rights. You couldn't charge a market rent. And that was the point of the legislation, though. It was to ensure your tenant and their immediate family had a right to stay in the property that they probably lived in for years.
And I think that what that then did cause to happen, you're right, and perhaps this was good in some respects. Street and Mountford removed the sort of almost trying to create a fiction or a fictional document that didn't match what actually happened as a way of bypassing what the law is. And very quickly then we had, I think it's the 1988 Housing Act, which for the first time introduced the assured tenancies, which were then further sort of reformed into this assured short-hold tenancies, which, I mean, I know there's lots of debate around this, but sort of rebalanced the rights, maybe a bit in the landlord's favour, but I think there was the debate was had, and there was probably
well, I mean,
a fairer...
some people argue we've now moved to some sort of an opposite regime where it's very landlord friendly in certain contexts, whereby
the
no fault evictions, which came at the end of the 1980s, with the idea of an assured short-hold tenancy agreement, which is what we see now. If you're going to grant a tenant to an occupier, it's an assured short-hold tenancy.
Ironically, with this case, and we would always say deal with the afterlife of the case, when we come across it in the context as lawyers, it's often in the area actually that me and you would work together on a case. I'm a dispute lawyer. You're more of a transactional commercial property lawyer. Where it is more relevant is in relation to commercial property these days.
Well, yeah, statutory protections aren't just for residential tenants. Business tenants have a layers of protection, and also agricultural tenants. So, the business tenants have the protection under the Landlord and Tenant Act 1954 in certain circumstances, which means your landlord cannot simply at the end of the lease ask you to leave.
But I'm thinking of various cases, and we won't name them, but various cases that me and you have been involved in, even, up until very recently, where landlords were trying to call something that a license, in circumstances where tenant had more or less exclusive rights of possession. The landlord never physically stepped into the building. A rent was payable, or a figure was paid. It was called a license fee or a service charge or whatever, but it was really a rent. And, it was set up for a period of time. And that case was the first one that we reached for in.
Well, it's a starting position for any question about whether or not what is in place is a lease or something else, and arguably what you're looking at first and foremost is this idea of exclusive possession, because what the common features that leases and licenses have, well, often it's for a period of time, and often there's money changing hands between the parties. So actually, it comes down to what is exclusive possession. Is the tenant there, or is the landlord coming and going? Is it truly a shared space, or is it exclusively occupied where the tenant has the keys to the place? Nobody else can access it except with the tenant's permission. That squarely will fit within the idea of exclusive possession.
What all of us lawyers will say, though, is that, it depends on the circumstances of the case. You sort of know it when you see it a little bit, I would say. Certainly what we have seen more recently, post-pandemic, is the rise of some of these shared working spaces, the WeWork type concepts, where you might rent a chair in an office building. One of our clients got one of these very nice premises, Shire House in Lichfield. Been there, really, really impressive spot. When you're renting a membership, I think is how it's done there at that club. And I know that was the WeWork model. That wouldn't be a lease, would it? That would be for the most part, would be, you not having any right to any specific part of that room. You can log into the Wi-Fi. You can get into it anytime, not day at night.
That's what the service, classic serviced office. Your landlord's often there with you. The landlord's responsible for often all the outgoings, and you're simply renting the chair and the desk. But
what I'm trying to say is, it doesn't preclude that type of arrangement from occurring. There can be licenses.
They can.
And that is a kind of example of a genuine license type arrangement or a membership type arrangement versus people are trying to sort of manipulate things to try and make it look like something that it isn't.
And in many respects, if that is the sole reason why the landlord is wishing to do that, then there are ways in which they can mitigate their position. You can exclude, in particular in the business context, the Landlord and Tenant Act 1954. Yeah, which means that the tenant doesn't have a right to ask you for a new lease at the end of the term. There's a procedure to go through to make sure that happens, but that will give the landlord the comfort that at the end of the fixed term, he either renegotiates with the tenant or asks the tenant to leave.
And it's not too hard a process, right? You go and see an independent lawyer who just makes sure you know your rights and signs a form to say that.
And if that's made clear from the outset, then that's the position that you go forward on. Historically, there was a difference in rent between tenancies that had the 1954 Act protection and tenancies that don't. But I think these days that isn't necessarily the case.
As ever, and what we say every time when we do these podcasts, it depends. Neil, thank you for joining me.
Thank you.